Welcome to today's YouTube video. I'm Alex Hernandez. I'm your personal professor. I'm joined here by, should we call him a student? I don't know. Murphy's Law. He's gonna be here now by my side, kind of supervising me. I think it fits perfectly. What could go wrong will. We've all been there and done that, right? Now today I'm going to be talking about issues that it simply relate to, and it goes with a prior post of what if you happen to receive a hearing for a 341 meeting of creditors and you happen to be a creditor. This could be whether you own a business and maybe someone has an outstanding balance with you, maybe it's business to business, or maybe you just loan money to a friend or family member and they obviously put you on the schedules when it comes to bankruptcy. So it'll make Thanksgiving and Super Bowl party a little awkward. But if you receive that notice, what are you supposed to do? Well, it's kind of this misnomer here where it's called the 341 meeting of creditors. You would think, based on logic, that all the creditors would be there in every single case and they're there arguing and they're going over everything. And the reality is that's nowhere near what happens. It's called 341 meeting of creditors because that's where you can find it in the bankruptcy code, section 341, where it explains the process and everything else. But when it comes to actual creditors being there, yeah, you're not gonna see them. They rarely go to that. Typically, if you see someone go, it's usually just that someone who's, um, you know, a friend or family member, a small business owner that received this notice and says, "Oh, I guess I have to go to court now." And you see, that's part of the terminology here. Um, to get lawyerly on you, you're not going to court because court implies that there's a judge there and there's a hearing and the court is making decisions based on the facts that are presented on the case and everything else. And the fact is, you're never going to see a judge at a 341 meeting. If a judge is at a 341 meeting, he's probably filing bankruptcy himself. Judges are prohibited from attending the 341 meeting of creditors. And on top of that, you rarely see them in Chapter 7 cases. 4 years that 4.5 years that I was in Jacksonville, never saw a bankruptcy judge for my Chapter 7 bankruptcy cases. I know they were on the floor above because the hearings happened to be at the courthouse, which is normal in big cities. If you're in a small city, it could literally be held anywhere if there's not a bankruptcy court nearby. But it's going to be actual a room, a hearing room, where the trustee will be present. So no judge, and who will be there? The trustee. And see, that's the thing, to go there and ask questions. First place, these are very short hearings. Not a lot of time is devoted to these hearings. So, and a trustee can't make a ruling. It's not like you can say, okay, I object, and the trustee is going to make a ruling, hit the gavel. None of that happens at a 341 meeting because it can't happen. The trustee doesn't have those powers. They have the powers to represent the bankruptcy estate. That means basically represent the best interest of creditors. But other than that, when it comes to bankruptcy and they ask you all the questions, what does a trustee do at the end? The trustee makes a recommendation to the judge, says, I think we're good to go on this case, and the judge will sign an order. So it's not going to be your typical hearing. Now, what if there is an issue and at this 341 hearing, you're really not going to get that message across? What are the options you have? Well, you see it there. For one, object. What could be the reasons to object? Maybe it's something that whether it's a friend or family member or this person who did business got X amount of money from you and immediately filed for bankruptcy. That could be an issue for the trustee. The trustee would make them pay that back. Are they paying it back to you? No. They're paying it back to the bankruptcy estate, and then everyone's going to get their share because that belongs to the bankruptcy estate. It doesn't belong to you, unfortunately. If there's other issues, let's say really fraudulent type issues, then you can do a 2004 examination. That's kind of just, it's just a deposition basically. It's a sworn statement. Though, you've seen movies of depositions and all that. It's just that they're just going to ask you questions, reference to the case. If you're the creditor, you can ask questions. When did you get the loan? What did you do with the money, etc. Not very common, but let's say it happens in, 10, 20% of the cases. Usually it's the trustee that does it, but to be clear, any party in interest can go ahead and proceed with a 2004 examination. Now, let's suppose let's just say it's chapter 7, even if it's chapter 13. You can't file what's known as a proof of claim. A proof of claim, you'll find out on the bankruptcy court website. It's just saying this is how much is owed. So it doesn't matter whether it's Bank of America, Chase Bank, Wells Fargo, whatever creditor you can think of, they're going to be submitting the same form as you. So don't get intimidated by, oh my God, I'm not used to this process, and I'm going to court. Realistically, you probably won't even have to go to court. If there is assets that have to be divided as part of the bankruptcy estate, you submit your form, and that's it. If there's any issues, I say, for example, that debt doesn't exist and you made it up, then the debtor could always file an objection and say, we don't know who this person is, etc. But for the most part, it's smooth sailing. You just submit your proof of claim. You probably have to do that locally at the clerk's office, or you should be able maybe through pacer.gov, which is the main website. You have to create an account and do all that, but you can do it through there. So at least as a creditor, you could be protected, as you see here, whether it's objecting, whether it's the 2004 examination, or proceeding with your proof of claim. Got it? Now, for those of you that are paralegal students and you have my textbook in your courses, feel free to always chime in like everybody else who's watching this video. Chime in, ask any questions, comments, do all that stuff. I always forget to say like. I say it like 10% of the time. So feel free to put a question down below and I'll be more than happy to respond to you. All right? So take care, everyone. I got more videos coming up. I'm finally catching up with my videos in reference to my blog post. So when that comes and I'm all leaving, I got big surprises coming to you where I actually explain filing the bankruptcy process step by step by step with the forms. All right. And for the paralegal students, I'm actually going to do the same thing, but I'm going to do it with the PowerPoint that you have access to already. You'll see a separate section for that on my YouTube channel. All right. Take care, everyone. Be safe. Have a good weekend. If you've seen this during the week, then have a good week as well. And I'll catch you up on the next video. Take care.